We begin this hour with a tense motions hearing in the Parkland shooter's penalty phase. Nikolas Cruz's defense asked Judge Elizabeth Scherer to recuse herself from the trial. Now, the defendant was also there today, but not the jury, as multiple motions were also on the table. Cruz's team wanted the judge dismissed after she lashed out at the defense for resting their case without notifying the court last week. Who can forget this moment?
State, are you going to have anything ready for today?
No. We're expecting,
there was 80 witnesses.
We're waiting for 40 more witnesses.
I just want to say this is the most uncalled for, unprofessional way to try a case. You all knew about this, and even if you didn't make your decision till this morning, to have 22 people plus all of this staff and every attorney march into court, be waiting as if it's some kind of game. Now I have to send them home. The state's not ready. They're not going to have a witness ready. We have another day wasted. I honestly have never experienced a level of unprofessionalism in my career. It's unbelievable.
Now, at this point in the trial, it's the judge herself who makes the decision whether she stays on the case, and she did, in fact, deny their motion. She's still on the case. The other motions heard today, the state asked to admit photos of swastikas that Cruz had drawn into evidence. Well, let's bring in now Court TV legal correspondent Julia Janae. She watched today's motion hearing and joins us now live in studio. Julia, you've actually been covering this thing from day one, so you're well aware of what's going on. You watched today's proceedings. What were some of the key takeaways as far as you're concerned?
Michael, all eyes were on the court to see how she was going to handle this defense motion to disqualify her honor, to get her to recuse herself from this case. As you mentioned, that motion was denied, but it was done quietly. It wasn't done in front of our cameras. It was in judicial chambers, something we have not seen often. She often puts things on the record, but because it was done in chambers, we don't know necessarily her thought process or exactly how she came to that decision, but we can, of course, understand that she likely did not agree with what the defense argued in this case. Now, the big reason that they were there was to discuss the state's rebuttal case. And one of those things that the state wants to bring up in their rebuttal case has to do with hate speech by this defendant and those swastika emblems that were on items that he owned on the day of the shooting. That has been reserved. The judge is going to come back and let everyone know on Tuesday of next week what her ruling is. Also, the motion to rebut, motion to limit the rebuttal, rather, by the defense. That was the big reason that we are here today. They want to keep out some of the evidence that the state wants to bring in particular, because they stopped the case where they did last week, stopped it during the middle school career of this defendant. They argue that this state prosecution shouldn't be able to bring in their experts who will talk about his antisocial behavior, which is what they have opined he's dealing with, and not a psychological disorder. Again, that motion is reserved as well.
Yeah, and that's an important one, because I think it's a bit of a gamble, the choice by the defense not to go forward to limit the state, and winning this particular motion on that issue, I think is super important for that gamble to pay off. Julia, why does the state believe the door has been open to allowing that symbol, the Nazi symbol, excuse me, and during their rebuttal case?
Right, that symbol that was on the backpack of this defendant, something he had etched into it while he was carrying out this deadly rampage, but it's something the jury hasn't heard about yet. They did see these markings in the classroom photos that the defendant drew when he was in middle school. There was a teacher on the stand, and the state was able to get it into evidence, but they want to highlight it even more once their case begins, their rebuttal case. But here's their argument in front of the judge, saying that this moment during the defense case, when the teacher was on the stand, that opened the door.
Obviously, the state has a right to rebut any defense litigation. Both defense experts testified as to the diagnosis of MD, PAD, and ARND. The state's rebuttal is that the defendant should be diagnosed with antisocial personality disorder. That hate speech contained in the searches by this defendant is relevant and certainly part of the expert's overall diagnosis.
The state had asked that the swastikas be redacted from that document. They were in disagreement with that, and we had arguments as to that. We asked the court to redact the swastikas in light of the fact that we had not received a pretrial ruling on SF 202. I then went through the procedural history of that motion. I don't want to do that again, so I'm asking if the court will accept the arguments and the timeline that I provided on September 1st of 2022. Over the objection of the defense, the court allowed the state, indicated that the defense would have to submit all of the documentation with all of the information, specifically the swastikas that we asked to be redacted. So it was admitted. It was admitted after we had requested that that information be redacted, and without the court giving the defense the benefit of a pretrial ruling like we had requested before the jury was seated.
Chief Assistant Public Defender there at the end, Melissa McNeil, arguing that the judge never ruled on this motion, something we at Court TV were watching very closely, but she ruled on it in part when she allowed that homework assignment to come in with those symbols, but she ultimately did not make a written ruling on the state's initial motion at the beginning of this case to admit those images in any form. So now we're waiting to hear if she's going to allow it in during the state's rebuttal case.
Yet again, another big ruling we're waiting for from this judge. Now, Julia, the motion to disqualify the judge, that's the big thing from today. It had some bold accusations from the defense. Can you tell us about their filing?
It did. This motion really went back through all of these instances that the defense says they were wronged by this judge. They say that this bias has leaked into this trial and has infected it, but they also put an affidavit that's signed by the defendant. Here's his own words in this filing. He says on September 13th, 2022, my lawyer advised me that at sidebar, the court, meaning the judge, threatened my lawyer that it would reprimand my lawyer in front of the jury by stating, I'm going to reprimand you in front of the jury, something the defense obviously has objected to. And it also goes on to another moment. Back on September 1st, 2022, the court brought in the jury before Ms. McNeil was present. And this is Cruz stating that he believes the court did this to embarrass the defense counsel and to make a point to the jury that the delay was caused only by defense counsel. I have reasonable fear that the court was attempting to poison the jury against my defense. Michael, though this was denied, very likely that all of this will come as part of an appeal in this case.
Yeah, and I can remember during the jury view, there was an issue as to her impartiality. They didn't want her to go along because they were worried about her. If she did, in fact, go along, they didn't want her to show any emotion. So there's been a little back and forth between those two from the very, very beginning. All right, Julia Janae, thank you so much for that report. Julia, appreciate it. Let me bring back in my guest. He's in studio with me, attorney and law professor Joe Richardson. Joe, first of all, I want to start with this choice by the judge, or the decision by the judge, not to recuse herself. Certainly not a surprise.
Not a surprise at all. She kept it in chambers, so there wasn't an issued ruling per se. There wasn't a whole lot of public argument and that type of thing. That's absolutely to be expected in terms of her not recusing herself.
Right.
They'll make their record. They'll do what they think that they want to do. They've threatened to move for mistrial. But I think the bigger problem that the defense has is if you're in the mud with the judge, the judge is imperfect. She's relatively inexperienced on these kinds of cases. But if what you're doing is confusing as well and double-minded, then you may have a problem that way, at least in terms of appealability or getting an appeal to be successful.
So it sounds like in your mind that there was some cause by what was done by the defense for the judge to act this way or to respond that way.
Yeah, absolutely. And, she could have taken the high road and admonished them with a little less emotion, right? With a little less flair and a little less style. But the point was well taken. They could very easily have said, after 3-4 more witnesses, Your Honor, we're actually going to be done with our case. Yeah. There's no good reason why they wouldn't do that other than to antagonize the judge, which, normally you're better off at least being even with the judge and certainly not coming off a certain way through the jury to the judge. They're watching what's happening with the judge. And so that's not a good thing for the defense. So it's actually inexplicable that they would do it that way. I understand why they would shut their case down, and hopefully that works for them. They still want that audience of one, but why antagonize the judge in the meantime?
Fair enough. And I'll push back a little just because these are professionals, very experienced. I don't think they would have done it to antagonize anyone. I think it was a last-minute decision, and that's sort of the way it played out. This whole idea with the swastika, and the defense is fighting very hard to keep it out. I'm wondering if that is one of the hills that they want to die on, meaning, do you think they're protesting too much? How important is this? If this gets in front of the jury, is that going to really be something that undercuts their case?
I don't know that it helps them, but to your point, how big a deal is it, relatively speaking, particularly if it has the potential to take away so much of everything else you're trying to do? You're trying to tell this story, and there's a lot of bad news here. There's what he did, which is coming into evidence. He did it to 17, he killed 17 people, he wounded 17 others. And so you really have to make a decision about which battles are the best ones to fight. And standing from here, I mean, I'm not in the well trying the case, but standing from here, you know, that may not necessarily be the greatest battle. I'm not saying that it's unimportant, but, you know, these things are inexact. It'll be interesting to see what the jury says on the back end about how important that was or was not for them. And I wouldn't be surprised if they said, you know, this wasn't the most important thing to us.
But it is one of the most hateful symbols in the history of our world. So I can certainly understand the defense saying, hey, if we can keep this out, let's keep it out.